This is the quasi-legislation session presented by Ian Rennie. And just a reminder, we will be recording this session and it'll be available on the Law Society's YouTube channel. If you have any questions, I'd encourage you to use the chat function. And I will pass the questions on to Ian. And otherwise, Ian, over to you.
All right, thank you, Glenn. So my name is Ian Rennie, of course, and I work for the Territorial Department of Justice. This is a seminar on quasi-legislation, and before we start, I just wanted to make it clear that any of the views and opinions that I express are not necessarily those of the Department of Justice. So without further ado, let's start. This presentation is based on a presentation that was given many years ago, 2007 or thereabouts. And some of the law has changed, and this presentation has been modified accordingly to take into account some of the changes in law since that period. Teaching objectives. What is quasi-legislation? How is it used? How can it be abused? Standards and codes of practice, in particular under the Safety Act, but we'll have a look at some other acts as well. There are some core references, so you'll find that these are textbooks of interest. Delegated legislation is quite a good one to understand what regulations are and what's involved in regulations and statutory interpretation. Colin Turpin's book is a basic book on the constitutional system of the British government. That is, of course, relevant to us because our system is based on the Westminster model. Gabrielle Gance is an English author. Her book is out of print, but this quasi-legislation has drawn heavily from her work. Even though it's out of print, it is available through interlibrary loans. Harris document is interesting as well, because it talks about quasi-legislation as the third source of authority for government action. In terms of case law references, P.S. Knight is a Federal Court of Appeal case, and that one will be discussed. And what I've done is I've taken that case and used it as a counterfoil to critique the analytical structure that I present in this seminar. Malone versus the United Kingdom is a criminal case in England where the European Court of Human Rights, I think that should be ECHR, is involved against the UK. McKenna is a PEI Supreme Court decision that's quite interesting, involving NFPA, National Fire Protection Association standards, and how they were used. And I think that's actually quite a good case to understand the confusion that's going around these issues. Statutory Instruments Act, of course, is an important statute in the Northwest Territories. Most provinces and even the federal government have similar acts. They might call them by different names. I think in some jurisdictions, the Regulations Act is quite fashionable. This is the outline of the presentation, rather hard to read. I intend to try and present what exactly my understanding of quasi-legislation is, how it differs from regulations. The Continuum of Legislation will sort of map it out with other forms of legislative instruments. How it is abused. So I've got two examples of abuse of quasi-legislation that are quite interesting, and they reveal a lot about the nature of quasi-legislation. Standards in their adoption. The standards are actually a type of quasi-legislation, and what it means to adopt is an interesting question. We'll have a look at the McKenna case again briefly, and then we have a look at the OHS regulations and apply that as an example, and then we'll apply the oil and gas regulations that is the subject, or sorry, the Canadian Electrical Code that is the subject of this Knight case, the Federal Court of Appeal case. can have questions at the end, but as Glenn has said, feel free to type in your questions, and I don't mind answering them as we go along, especially if the context is relevant. Quasi-legislation. So the definition of quasi, as it were, virtually, in close connection with the word following, kind of, resembling, simulating, but not really the same as if, almost as. So whatever quasi is, it's some sort of modifier of legislation. So it's not quite legislation, but it's similar. In the past, quasi-legislation was conflated with subordinate legislation, which is regulations and regulation making. And I have a Supreme Court case from 1953 that actually shows that. Quasi-legislation really sort of developed out of World Wars I and II with the rise of the administrative state and its use in controlling the economies for war production. So this is the rise of the administrative state that we know of today. And there was also a corresponding rise in the use of regulations, which we call subordinate legislation, because they're subordinate to the empowering act. Colin Turpin has a quote about what is quasi-legislation that's kind of interesting to look at. Administrative authorities, in particular government departments acting in the name of ministers, frequently make rules without statutory authority, which are intended to regulate the way in which statutory or other discretionary powers will be exercised. These are rules of administrative practice, not of law, and rulemaking of this kind is commonly described as administrative quasi-legislation. So what I did was I tried to pull out what I call axioms of quasi-legislation based on that definition. So the source of the authority for the instrument does not flow and should not flow from the legislature. Typically in statutes with regulations, there is a regulation-making provision, or perhaps peppered throughout the act, there might be regulation-making provisions. But in the case of quasi-legislation, there is no authority to make quasi-legislation. Why should there be? Because the authority would be to make regulations. Regulations are a source of law. Quasi-legislation, I would argue, is not a source of law. The subject matter of the instrument is administrative in nature. So it could be technical, but generally it shouldn't be something that imposes serious obligations on people. So for example, criminal matters. We'll see that in Malone. There is a minimal or perhaps no legal effect to the instrument. There must exist some form of consensus by the subject to the instrument that they will comply with it. So typically you see that in standards. The standards making body is represented by stakeholders from the industry, and they'll contribute to the compilation of the standard. And those stakeholders have agreed to what the standard should say, a form of consensus. The instrument must be readily accessible to those subject to the instrument. So quasi-legislation should really be accessible. If it's not accessible, there's an issue. And we will see this in other cases, particularly the PEI case. Axioms of quasi-legislation. The instrument is quasi-legislation if there is no statutory authority for the instrument. The instrument concerns administrative matters. The instrument has no legal effect. The instrument is consensual and complied with voluntarily, and public notice is given of the instrument. I would argue that if any one of these elements is not met, the instrument is not quasi-legislation, but some form of legislation. It could be a regulation, an act, rules, authorized or unauthorized. Unauthorized enactments are likely an illegal exercise of powers that have not been delegated. We call that ultra vires, the act, so outside of the authority of the act. We will look at that in Malone. How does quasi-legislation differ from regulations? So what I've constructed here is a matrix or a table with those 5 things plus examples. So the source of authority for a regulation is to be found in a statute. Quasi-legislation is typically the standard-making body, the association of stakeholders or industry. Subject matter in a regulation could be anything that flows from the Act. Quasi-legislation is administrative. And so we all know that criminal code is a statute. There are regulations under the criminal code. So, but quasi-legislation should not be dealing with criminal matters because it's not an administrative or technical subject area. Legal effect. Direct legal effect in a regulation, it is a source of law. In quasi-legislation, it is not a source of law. How is it made? Consultations, government policy. Quasi-legislation is made through consensus. Public notice. For a regulation, it must be published in the Gazette of the Northwest Territories, in case of its, or as required by the statute. Sometimes some things are exempted. For example, the rules of court or the rules of law society don't have to be published in the Gazette. They are exempt from publication under the Public Printing Act and other enactments. Often in quasi-legislation, copyright is attached to the standard or the quasi-legislative instrument. Typically, publication there is a reference made to the publication, the quasi-legislative instrument, but the quasi-legislative, instrument is not actually published or replicated. In practice, the notice or availability of the quasi-legislative instrument is required or is made available by the standard-making body or other associations where it has been incorporated by reference into a regulation or a statute. The purpose behind that is to give public access, because what you do not want to do is to try to prosecute people for failing to adhere to a standard and then find out that the standard is not readily accessible because it's copyrighted. We're talking about private copyright, by the way. Examples of a regulation: occupation health and safety regulation, rules of law society. Examples of quasi-legislation: Canadian Electrical Code, Codes of Practice under the Safety Act, CRB-OH bylaws and codes of ethics. CBA Code of Professional Conduct, I would argue, is also quasi-legislative. We call this Scrutiny of Regulations. So in the Statutory Instruments Act, there is an interesting section, subsection sub 3. And this is common to most statutory instruments acts across the country and federally by whatever name they're called. So we call this the statutory examination process. The registrar of regulations, who is a public officer and appointment, in consultation with Deputy Minister of Justice, shall examine proposed regulations that are put before him or her. And there's these 4 heads that the registrar has to confirm. So, is the draft regulation authorized by the act under which it is to be made? Okay, if not, it's ultra vires. Does it constitute an unusual or unexpected use of authority under which it is to be made? Does it trespass unduly on existing rights and freedoms under the provisions of the Canadian Bill of Rights? And the form of the drafting of the proposed regulation has to be in accordance with established drafting standards and conventions. Quasi-legislation is not subject to that because it is not legislation, it's not regulations. There is no review of quasi-legislation by the Registrar of Regulations. Why? Because these are not proposed regulations. The statutory examination process, no legal advice is given to the quasi-legislation making body by the Department of Justice. Possible that they might receive legal advice from outside sources. And typically, the drafting conventions do not comply with standard drafting conventions of legislation. So, for example, if you were to look at National Fire Protection Association codes or even the Codes of Practice under the Safety Act, you would find that the language is not legislative language. Offenses generally are not set up with the proper elements to support a prosecution under them. And there is a great deal of ambiguity. That's because the standards are not written in legislative language, they are written in some form of lay language. So that's kind of interesting. It's very rare to see a standard which is written in legislative language. I think we've come across one that might, and it had to do with radiation. Continuum of legislation. So we have here basically a Cartesian coordinate system. Legal effect is on the scale on the horizontal axis on the far left, and then voluntary compliance is at the other extreme on the right. So an act is a statute. So I would think that an act has a great deal of legal effect. Obviously, the primary statute that has legal effect is the Constitution Act, including the Charter. And then I've sort of tried to talk about the other ones. There's some degree of subordination. So I've put the Northwest Territories Act as being rather important because it has a constitutional aspect to all the other laws. The Human Rights Act is quasi-constitutional aspects to it, and then the Safety Act. The statutory instruments or regulations would be next, followed by non-statutory instruments. Incidentally, I put the Supreme Court rules in a bit of a hierarchy under the statutory instruments, because there is authority under the Judicature Act for the Supreme Court rules to override any other enactment that unless that overriding power is explicitly forbidden in the other enactment. So it's a bit of a hierarchy there. Then non-statutory instruments, NSIs, are put there. NSIs are not considered in this jurisdiction at the moment to be statutory instruments, hence the name, non-statutory instruments. So they don't actually have to be published, and they also do not require to be translated under the Official Languages Act. At the bottom on the left, I've put in OECs and OICs. OECs, and I guess the other one in this jurisdiction would actually be RODs. So records of decision and also orders in Executive Council. Orders in Executive Council are a special case. They are residual of prerogative powers to make legislation. They might have a character or quality of an act or a regulation. So perhaps the OEC should be moved more into the regulation side. In terms of non-statutory instruments, they have some legal effect, and it's necessary for achieving the purposes and objects of the act on which they are based. But there might not be explicit authority in the act to actually create that order or non-statutory instrument. This is an attempt to cover that, still in accordance with the act. Under quasi-legislation, I've put things such as the code of practice, standards, and then codes of ethics. Again, we're well into the area of voluntary compliance. So I think this is kind of an interesting slide to sort of put everything in perspective. Abuse of quasi-legislation. So I want to look at two cases very briefly, the Malone case and this IEEE wireless Wi-Fi case. So the Malone versus the United Kingdom, if you get the PowerPoint slide, it is hyperlinked if you want to read the case. UK Home Office, which is the equivalent of RCMP or Solicitor General in Canada, intercepts postal and telephone communications for decades. They had no statutory authority to do that, but they did it as per the usual practice. UK House of Lords, which at that time was the equivalent of what we would call the Supreme Court, upheld the practice. The Vice Chancellor would be like the Deputy Chief Justice, I guess, argued that the government has the freedom to do all that which is not prohibited by law, which is an interesting argument. And I hope alarm bells would ring to every lawyer in this presentation when they hear that. And we'll see why shortly. The irony is that Vice Chancellor McGarry is a prominent author of legal texts. And he wrote a pivotal article in the Law Quarterly Review that actually talked about quasi-legislation. and very much along the lines of what I am presenting. European Court of Human Rights threw out that reasoning for significant intrusion on the rights and privacy of an individual in a criminal context to be authorized. That can only be authorized through explicit legislation by Parliament. Here, the Metropolitan Police had usurped the legislation-making power of the Westminster Parliament by doing this and following some sort of policy or quasi-legislative instruction. So if we apply the matrix to the Malone case, there was no statutory authority for the quasi-legislation that had been passed by the Metropolitan Police and the Home Office. That's fine. The instrument concerns administrative matters. Well, it doesn't. It concerns criminal matters. Fundamental freedoms are affected. So right then and there, it fails. This is not quasi-legislation. The instrument has no legal effect. Well, in this case, it did have legal effect because it intruded on the privacy and other rights of individuals. The instrument is consensual and complied with voluntarily. There was no consent or participation in the formulation of the instrument, except by the police, I guess. Public notice of the instrument was made. In this case, there was no public notice. So this is not quasi-legislation. It's an unauthorized statute, and therefore it's a usurpation of the legislative making powers of Parliament. So it's not quasi-legislation. This is what it actually is. Just B.B. Harris has a comment about this argument that but the Vice Chancellor had put forward. And this is why the alarm bells, I suggest, should have been ringing when you heard about it. If the government were free to make laws, I'm not going to read through the entire thing, but basically the default position is that Parliament is not authorized to do something, okay? Especially it affects the lives of individuals. Ultimately, the argument is the community preference is for Parliament to make laws and confer limited lawmaking powers on other bodies after foreseeing and considering the lawmaking needs of the community. It is not the default position that government can do anything it wants until it's expressly prohibited. It's the other way around. Government cannot do anything it wants unless it's been expressly permitted. This sort of touches upon something in legislation called a Henry VIII clause. Regulations that purport to change an act. We do have examples of that, even in this jurisdiction, and you can see that in the Schedule C amendments regulations to the Legislative Assembly and Executive Council Act. Basically, Schedule C are the allowances that are available to members of the Legislative Assembly. The amendment of that schedule by regulation is actually authorized by the statute. So that's fine. And principle of parliamentary sovereignty would apply in that Parliament can do whatever it wants, or in this case, the Legislative Assembly. This sort of leads us, excuse me, this leads us into the conundrum that Wade sometimes talks about, that you probably took in basic administrative law. The Westminster Parliament could make an order banning smoking in Paris, right? Making it illegal to smoke on the streets of Paris. It's entirely within the realm of its powers to do that. Whether that is enforceable is another matter. But it ties back into the question of parliamentary sovereignty. Henry VIII was notorious for, so he was part of the executive, and he was notorious for inserting clauses that would undermine the authority of Parliament and allow him to declare statutes that were passed by an unruly Parliament to end. So it was an attempt at undermining parliamentary powers. Generally, Henry VIII clauses are frowned upon. They do exist. They should probably be avoided. And for everybody's benefit, this is a contentious matter again, big time in the UK. And I've got a hyperlink to a Financial Times article on it, because with the oncoming of Brexit, a lot of the replacement legislation is giving enormous amounts of powers to the ministers of the Crown and the executive branch of government, including bypassing the Parliament. So that is a problem and a topical issue even at this time, even though it dates back to Henry VIII. IEEE 802.20. So in 2006, IEEE was working on a group standard for mobile brand wireless access. Member of the working group, a crafty engineer, decided to direct the working group's work in such a manner that the draft standard would absolutely infringe on an existing patent in which he or his employer had some interest. Patent is an enactment or type of regulation. It grants the applicant or owner a monopoly for about 21 years in return for his or her public disclosure of technology. If one infringes on the patent, the owner may sue the infringer and recover proceeds, seizure of the infringing equipment, and the inventory. The way to not have this happen, of course, is to enter into a licensing arrangement with the patent owner. If IEEE were to adopt the standard, then any person applying the standard would infringe the patent. This is of commercial interest. In effect, the standard quasi-legislation was being drafted to have a legal effect through the patent infringement, and it was a deliberate attempt. In patent law, this would be an abuse of process and would lead to a declaration that the patent is invalid, because patent jurisdictions fall under the equitable jurisdiction of the court. And a series of lawsuits in the US aimed to do exactly that. Eventually, IEEE disbanded the working group entirely. If we look at the matrix applied to the IEEE standard, what exactly was the IEEE standard? There was no statutory authority for the instrument. Fine, that's a good indicator that it's quasi-legislation. The instrument concerns administrative matters, in this case, technical matters. Fine. The instrument has no legal effect. Well, by deliberately setting up an infringement of a patent, that is having an unanticipated legal effect. So were it a regulation, it would be an unanticipated legal effect, but it's not a regulation. So it fails here because it will have some form of legal effect. The instrument is consensual and complied with voluntarily. While the IEEE standard process is consensual, there is deception going on here. How can consent exist if there is deception? Public notice of the instrument, the standard was never finished, so I think that's indeterminate. So we have two X's here on the matrix. Just one X is enough to invalidate the instrument under review as being quasi-legislation. So I would argue that the IEEE standard that was crafted was not quasi-legislation, largely because of this legal effect aspect, the deception as well. I mentioned the examination process. Were this a regulation, you can see that under paragraphs B and C, it would have failed. The consequences of a failure under the statutory examination process would result in probably the Register of Regulations issuing a letter to the proponent of the regulation-making authority, pointing this out. How standards are incorporated. So there's an old form, and we see that in the Fire Prevention Act. So where a code of rules or standards concerning the subject matter of this act has been promulgated by any association, person, or body of persons, and is available in printed form. Notice it says available, so it has to be in the Gazette. The Commissioner, on recommendation of the Minister, may adopt the code by regulation, and on adoption, the code shall be in force in the territories, either in whole or in part, or with such variations as may be specified in the regulation. Kind of interesting. What does it mean to adopt the code? What does it mean that the code shall be in force? I would argue that to adopt the code by regulation, okay, a regulation adopts the code, that's fine. But the code shall be in force. What does it mean to be in force? In force as what? In force as a regulation? I don't think it can possibly mean that, because if the code were in force as a regulation, it would not be quasi-legislation. It would be some form of regulation, authorized or not. That provision was amended in 2010. I've underlined the portions that were amended, but I'm not sure the change is all that substantive. Where a code of rules or standards respecting a matter referred to in this act has been established by an association, person, or body of persons, in this case, National Fire Protection Association, and is available in printed form. So that seems to be those paragraphs at the beginning of the previous one, A and B. The Commissioner, on spelling error, on the recommendation of the Minister, may by regulation adopt the code as established or as amended from time to time. Amended from time to time is a magical word, or a magical set of words. And basically it means that if you're adopting a code, you're adopting the code as it is currently. If you insert the words as amended from time to time, that means that if the code is amended, those amendments automatically are adopted as well. And upon adoption, the code is in force in the Northwest Territories. So the previous iteration talked about just in force in the territories. That's just a stylistic change that has been adopted to most GNWT legislation. But we still have and upon adoption. So what does it mean to adopt? And what does it mean to be in force? Okay. Adoption and in force, what exactly do we mean? If we mean it as having legal effect, then surely that will violate one of our fundamental axioms as to what is quasi-legislation. So this is a segue into McKenna. So I think yeah. So this is an attempt to apply the Axiom Analysis to probably a code under the Fire Protection Act. Does in force give the code statutory authority? If yes, this is a violation. Does it concern administrative or technical matters? Yes. Has legal effect if what is meant is in force? So that should actually be an X, not a check mark, because it fails, right? The condition is that the instrument has no legal effect, but it might have legal effect if it's in force as a regulation. The instrument is consensual. It's probably consensual, although GNWT can vary the code or standard as it wishes. So I would argue that that portion of that provision, if the quasi-legislation were amended or altered by the GNWT as it wishes, it's no longer consensual. There is no public notice. It's kind of ambiguous what we mean by adopt by regulation. Does that mean publishing a code in the Gazette or variations, or just giving notice of where to find these? Publication in the Gazette is necessary for all statutory instruments. We will revisit that in the Federal Court of Appeal case. So looking at McKenna, okay, this is a fire protection case. And you can see that the provisions of the Fire Prevention Act in PEI at this time were very similar to what ours are currently or were in 2007. If a code of fire safety rules or standards for fire safety has been promulgated by any association or body of persons and is available in printed form, the Lieutenant Governor in Council may, upon the recommendation of the Minister or by order in Council, declare such codes and standards to be in force either in whole or in part. Very, very similar to the 2010 amendment. Again, it doesn't really answer what it means to be in force. I don't think when we say enforce means that it's enforces a regulation or law. Note how the Fire Marshal used the NFPA codes and standards. They were used as one of 3 factors by the Fire Marshal to consider certain things and reach certain conclusions. So if somebody wasn't following the NFPA codes and standards, then the Fire Marshal has to conclude that there has been a contravention of the NFPA code. There is an absence of others, in this case, there's an absence of other suitable alarms or equipment. There's no suitable and efficient fire extinguishing equipment. If A, B, and C, then the Fire Marshal may order. So this ABC business is setting up a condition precedent to authorize the Fire Marshal to make the order. If that condition is met, the Fire Marshal is authorized to use his or her discretion in making the order. The convention of the NFPA standard was therefore one of factors giving rise to the condition precedent. This was all obiter in McKenna, as the case centered around a judicial review of the order, not as to the nature of the contravention and the NFPA standard. McKenna, the Fire Marshal initially refused to provide the person to whom the order was issued with the NFPA standard or relevant extracts thereof. His grounds were that to do so would violate the copyrights in NFPA, National Fire Protection Association. The presiding judge was not impressed with that argument, and I don't think you should be either. Fundamental natural justice principle applies that all laws are public. It's an access to justice issue. And this is at the core of CCH Canada Limited versus the Law Society of Upper Canada. So that's a legal publication case. Axiom Analysis. So if we apply this matrix to the code that was discussed in McKenna, is there statutory authority for the instrument? No. There is statutory authority for adoption of the instrument, but not to make the instrument. Does it concern administrative matters? Yes, technical. Does the instrument have legal effect? No, it simply allows a public officer to consider non-compliance in deciding whether to exercise his or her prosecutorial discretion. Is the instrument consensual and complied with voluntarily? Yes, it was made by the National Fire Protection Association, of which there would have been representatives from various jurisdictions and stakeholders. Public notice is given to the instrument. There was no public notice. Copyright restrictions were applied, which is a problem. Nevertheless, in this particular case, despite what the presiding judge said in the previous slide, notice was given where to get the code, and the subject did have access to it. We have a look at the Safety Act, Section 18. Where a code of practice is approved and issued by the Chief Safety Officer under Section 3, he or she shall cause to be published in the Northwest Territories Gazette a notice identifying the code, specifying the provisions of the Act or the regulations to which it relates, stating the effective date of the code, and indicating where copies of the code can be obtained. So it's a notice, and it's not actually a republication of the standard or the code of practice or quasi-legislative instrument. It's just identifying what we would call metadata of relating to that. For the purpose of providing practical guidance with respect to the requirements of any provision of this act or the regulations, the Chief Safety Officer may approve and issue such codes of practice as he or she considers are suitable for that purpose. So you can see this word approve and issue. It's not making regulations. It's not a regulation making power. How are codes of practice used? So if we look at Section 22.1 of the Safety Act, this gives some insight into how it is used. The code is admissible as evidence in the prosecution of defense. Just because a person doesn't comply with a code or quasi-legislative instrument that has been issued and adopted, does that mean that the person is in contravention of the basic safety requirements under the Safety Act or its regulations? Not necessarily, because their practices might actually be safer than they would be if they had followed the quasi-legislative instrument. There is an evidentiary burden, obviously, on the part of the person who's being charged, that they will have to prove that. Had they followed the code of practice, then I think there's a presumption that that they were acting okay. Codes of practice under the Safety Act are therefore quasi-legislation. In a sense, the function is the same as in McKenna. Failure to comply with a code of practice leads to admissibility of the code as evidence, and that evidence is then weighed by the judge in reaching a decision in the prosecution. I think there's a presumption that if you are complying with the code, everything's fine. So here's the codes of practice under the Safety Act being applied to this matrix. Is there statutory authority? Yes, but the statutory authority authorizes not the subdelegation of regulation-making power, but rather the authority to make quasi-legislation, codes, not regulations. Does the instrument concern administrative matters? Absolutely. It's technical matters. Does the instrument have any legal effect? I would argue that it has no legal effect on any person. However, it is authorized to be admissible as evidence, although nothing is said on the weight. Instrument is consensual and complied with voluntarily. Chief Safety Officer approves of the codes of approves of the adoption and issue of the codes of practice. The Chief Safety Officer is the chairperson of the Safety Advisory Committee under the Act. The Safety Advisory Committee is a consultative body drawn from stakeholders. There's no legal requirement for compliance, but these are best industry practices. Public notice is given of the instrument, yes, but it's just the notice of the metadata. It's not actually publication of the data. So I think the codes of practice are actually a form of quasi-legislation in this matrix analysis, as it should be. Now, this Federal Court of Appeal case is kind of interesting, and I think it's a foil to critique this structure analysis that I've presented so far. It's a 2018 case, so it's fairly recent. It's a fairly high authority, Federal Court of Appeal. There's a majority decision and a minority dissenting judge. The case is an appeal, it's basically a copyright case. Copyright is intellectual property, and that is an area of federal jurisdiction, hence the federal court. Canadian Standards Association copyrights were upheld, especially the Canada Electrical Code. Unfortunately, the quotes of interest are all obiter, and also from a dissenting judge. So let's just have a look at the matrix applied to the Canada Electrical Code. There is no authority for the instrument. Okay, so the question is, the problem is that in this case, I think one is actually looking at the issue of incorporation by reference in a regulation of the quasi-legislation. The quasi-legislation itself is not authorized by statute, and it is not does not have any statutory authority. The regulation, of course, does. So the matter here is incorporate what it means to incorporate by reference quasi-legislative instrument in a regulation. Does that impart, or does that change the quasi-legislation, in this case the electrical code, to something that has that is regulation-like or even a regulation? The instrument concerns technical matters, so that's fine. The instrument has no legal effect. Quasi-legislation has no legal effect. The act of incorporation in the regulation might. So it's the regulation that has legal effect, not the quasi-legislation or the code. The code was reached through a CSA committee, so the code is voluntary, composed of stakeholders. Public notice is given. So I think that was done, and you can see that in paragraph 30 of the judgment. So the dissenting opinion is kind of interesting. Webb, Justice of Appeal, has a look at the Canada Oil and Gas Installation Regulations. And I think this second subsection is kind of important, which I've put in red font. Unless otherwise provided in this Act, regulations made, so this is coming from the parent Act. Regulations may incorporate by reference the standards or specifications of any government, person, or organization, either as they read at a fixed time or are as amended from time to time. So incorporate by reference. What do we mean by incorporate by reference? Does that mean adopt an issue or adopt, as we found in the other legislation? If we have a look at the Ordering Council, a reference to a standard or specification shall be considered to be a reference to that standard or specification as amended from time to time. So that's the incorporation by reference. 11 sub 1, we will look at again in a short while, because that sets up the offense. So subject to subsections 2 and 4, all electrical motors, lighting fixtures, electrical wiring, and other electrical equipment, technical matters, on installation shall be designed, installed, and maintained in accordance with. So shall be, it's interesting, the construction there, shall be, it's a little bit passive because it hasn't identified on whom a particular liability rests. In our drafting style, we wouldn't use shall in this context, we would use must. And the reason why is because the subject, all motors, lighting fixtures, electrical wiring, and other electrical equipment, is inanimate. So a contravention of that would be some form of irregularity, not necessarily an offense. Section 60 of the Oil and Gas Operations Act. So 60 sub 1, every person is guilty of an offense who contravenes this act or the regulations. So if the regulations incorporate by reference quasi-legislative instrument, Canada Electrical Code, does that mean that the regulations have been contravened when a party doesn't comply as they're required to with that code? We can see that there are consequences under subsection 2, fine or even imprisonment. And here's the reasoning of Justice Webb. As a result of these provisions, a failure to comply with the code could have various serious ramifications, including the possibility of a term of imprisonment of 5 years. Other regulations that adopt the code in whole or in part would also provide sanctions. Although the standards were first developed as a voluntary standards, given the serious consequences that could arise for failing to adhere to the code as adopted by the federal government on various provincial governments, it would appear that they should no longer be considered voluntary standards. Since the code is incorporated by reference into the regs, the code is part of the law. Since breaching the code results in severe penalties, it has legal effect. Incorporation by reference to the code transforms the code from quasi-legislation to something with legal effect, and it is therefore no longer quasi-legislation, but a type of regulation. Applying the Canadian Electrical Code again, I've got these X's on my analysis. Sorry. This is, I think this is Justice Webb's approach envisioned in this. He would argue that it has legal effect because of the incorporation by reference. So it does actually transform the code into a regulation. So this analysis is wrong, okay? This was my analysis. And it's largely because the X's, in Justice Webb's opinion, are actually check marks. So my critique of Justice Webb's decision is a problem with statutory authority or lack thereof. What does it mean to adopt, or in this particular case, the Federal Court of Appeal case, what does it mean to incorporate by reference quasi-legislation? Denial of problems of unauthorized subdelegation of regulation-making powers to standards body it's not even mentioned or considered. The failure to examine copyright issues and access to justice, publication defect is not mentioned. How can you have a regulation that nobody knows about in detail, let alone translate it? Failure to consider a type of language in the code. The code is not written in legislative language. And as I pointed out, there's a defect in that the onus or liability imposed on an individual is not necessarily clearly identified. Webb cited Her Majesty the Queen versus St. Lawrence Cement, and I just want to draw your attention to the last sentence in paragraph 18. I realize that in this particular case, they're looking at some work by Francis Bennion, a well-known legislative drafter. The effect of incorporation by reference is that the material incorporated is considered to be part of the text of the legislation. I think Francis Bennion would agree with that, but the text of the legislation, I'm not sure that it could be considered as actually a regulation or having legal effect in its own right. And I don't know if Francis Bennion would have agreed with that. Of course, he's passed on. In section 19, or paragraph 19, we can see this reference to British Columbia Court of Appeal case, R versus Sims. An interesting question is that these are all criminal law cases, except for the last one. Criminal law is a little bit different in that there's a presumption in favor of the accused, if there's any doubt. So I'm not sure that criminal law cases is really a useful comparator in this situation, because we're dealing with administrative or technical matters. Now, I realize that the Malone case, of course, dealt with criminality, but it was very clear in that case that criminal matters are not technical or administrative matters and should not even be the subject of quasi-legislation. The St. Lawrence Cement case hinged on the failure of government to provide adequate judicial notice of guidelines that were being relied upon for a prosecution. Emissions standards were adopted by means of the guide, registered as a regulation, and incorporated by reference. Nowhere in St. Lawrence does it indicate that the standard incorporated has legal effect. And here I mentioned that Rowell, so this is the British Columbia Court of Appeal case that I mentioned, is used in criminal cases, and there are different presumptions than in non-criminal cases. And I wonder if there's a statutory interpretation error underlying this comparison. Canada Oil, the issue is incorporation by reference of quasi-legislation, not of legislation. Those guidelines are registered as regulations, so they arguably are regulations. Webb, the result is that when the code was incorporated by reference, it was to be considered as part of the text of the regulations. It became an integral part of the regulations as if it had been reproduced in full in the regulations. Potential penalty for a breach of provision of the code is not altered because the code was incorporated by reference rather than being set out word for word in the regulations. The problem is the code did not actually set out penalties. Penalties are set out in the regulations. So I think the focus is a little bit off. It should be on the regulations, not on the code. So we can see here back to this order in council. Section 11 sets out the offense provision, not the code. But it's also a little bit of poor drafting, because is there actually an offense provision set out here, and on whom does the liability rest? Breaches. The code itself has no legal effect, so I would disagree with Justice Webb. If it did have legal effect, it would be an unauthorized subdelegation of regulation-making powers. I think Webb fails to complete the analysis. Prosecuting a breach is not flowing from the code, but rather from the, in this case, the order in council, the legislation. It's executive legislation. Notice that the wording is passive and no actual liability is placed on any specific party. Is the failure to comply merely an irregularity, or is it actually an offence? That's not clear. Why is no reference to the pivotal work done in England and Wales in the subject? It probably doesn't matter because all of these comments in Webb's dissenting opinion are obiter, and it is a dissenting opinion. But there might be a critique of my analytical structure that I presented here, so I think it's worth considering. And at the moment, I think some lawyers prefer the dissenting opinion approach of Webb because it's fashionable and simple to understand. But is it right? So in summary, what we've done is we've had a look at the definition of what is quasi-legislation and then the axioms or the framework for trying to analyze an instrument to determine if it is quasi-legislation or something else, typically an authorized or unauthorized regulation. How does quasi-legislation differ from regulations? The big one here is, of course, legal effect, but really it's all of those 5 things in the framework or the matrix that should be considered. We briefly saw the continuum of legislation, and then we had a look at different ways in which quasi-legislation was abused, looking at the Malone case, that's the European Court of Human Rights case, and then the IEEE case. We had a look at standards and their adoption, and then we had a look at the McKenna case, where quasi-legislation and the following of a code or standard can be used by a decision maker in making a decision or exercising discretionary powers to reach a conclusion that a prosecution should happen. Relevance to OHS regulations, we had a look at how this applies under the Safety Act and the OHS regulations and the codes of practice. Then we had a look at the Knight case, which I called the Canada Oil case. Or no, I didn't call it the Canada Oil case. The Knight case, so that's the one where the Canada Electrical Code was under review. I think that case, Webb's dissenting opinion, is of great use because it provides a foil and really a critique of the foregoing analysis that I provided here. I don't have an answer as to what's right or not, but there might be some debate and it might be a justiciable issue. So it's kind of an interesting subject. I'm open for questions. So Pat, I'll ask Glenn if there's any questions.
Thank you, Ian. One of the questions we've had from a couple of people is whether or not people could get your presentation. And I know there are a couple of bumps that you identified in it. So perhaps if we could ask you to rectify those small typos and then send it to us, and we will circulate it to all the people who are attending this session. We will also then post it with the recorded copy of this session.
Yes, of course.
All right. Any questions? Any other questions for Ian? Ian, there is another question. One is whether the decision of Ainslie on the Ontario Securities Commission was still good law, where the Ontario Securities Commission tried to give legal effect to a policy. Are you familiar with that decision?
I'm not familiar with that decision. What I would recommend is applying the matrix to the policy to try and determine what the nature of the policy was. I'm not familiar with the case.
All right. It appears there is nothing else. So with that, thank you, Ian. Again, thank you everyone for attending. This session was recorded and will be up on the Law Society's YouTube channel as soon as we get the technical stuff done. Thank you, everyone. Enjoy your afternoon. Thanks, Ian.
Thank you.